Zinzi, Lukona's there.
Hi, Nicole. Yes, I am. I'm just almost home. I ran a little late from my previous engagement, but I'm here.
Excellent. All right, well, I am going to start. It is 3:02. Welcome, everyone. Thank you for joining us for today's webinar, Phala in Focus, Constitutional Process and What Comes Next, hosted by Defend Our Democracy. My name is Nicole Fritz. I am a member of Defend Our Democracy's National Working Committee. I am also the Executive Director of the Campaign for Free Expression, and we are very lucky today to have two speakers who are going to take us through the ins and outs of both the Constitutional Court judgment that was delivered last week and what comes next, what the broader political context is. Sorry, I'm just getting a horrible echo. Can I just ask people to mute themselves? Great, thank you. So we were scheduled to have Lawson Naidu join us. Unfortunately, Lawson has been unexpectedly detained, but we are fortunate to have Kyle Jordan stepping into the breach, as it were. Kyle is a researcher at CASAC, the Council for the Advancement of the South African Constitution. He is also a doctoral candidate at Stellenbosch University. He holds an LLB and previously served as law researcher at the Supreme Court of Appeal, where he clerked for all of the justices, including Chief Justice Mandisa Meyer, when she was president of the Supreme Court of Appeal. He has varied research interests in constitutional and administrative law, public procurement, and the public-private divide. And so he will give us very valuable insight into the judgment that was handed down. And then following Kyle's presentation, we will have Lukona Nguni, who is a governance, politics, and development specialist. He will be well known to you. He is a frequent public commentator. He is very well respected for his public intellectualism, his commentary on current affairs in South Africa and developments around the globe. He currently serves as the acting executive director and head of policy and research at the Rivonia Circle, which is a non-profit company focused on finding innovative solutions to strengthen democracy in South Africa. So we're here today to speak about the ruling, which was handed down by the Constitutional Court on the 8th of May. At the center of that judgment is essentially Section 89 of our Constitution, which relates to impeachment. That provision provides that the National Assembly, by a resolution adopted by a supporting vote of at least 2/3 of its members, may remove the president from office only on grounds of a serious violation of the Constitution or the law, or for serious misconduct, or the inability to perform the functions of office. So that's central to the case. The political parties, the EFF and the ATM, took the outcome of a vote not to impeach President Ramaphosa, which was taken in the 6th Parliament, to the Constitutional Court. That vote had come about after an independent panel's finding that President Ramaphosa had a prima facie case to answer regarding the theft of apparently several $1 million from his Phala farm. The court was required to determine whether its exclusive jurisdiction was engaged in respect of the rule which was challenged, which set out the way in which the impeachment process was to run, and was required to determine whether it had exclusive jurisdiction in respect of the impugned vote, which was the vote taken by Parliament in terms of the rule that had been formulated by the National Assembly. Exclusive jurisdiction, a technical question to determine whether it was only the Constitutional Court that could determine the constitutionality of these acts. The court was also required to consider whether the matter had become moot and whether the delay in bringing the challenge was unreasonable, such that it should be dismissed. But those essentially are sort of technical questions, and the two primary matters that the court was required to consider, and I think which will concern us today, was firstly the constitutionality of the rule which Parliament had made to regulate the impeachment proceedings, and secondly, the constitutionality of the vote taken under that rule, where a majority, and it was an ANC majority, had prevailed, having the effect that the process would not proceed to a formal hearing before an impeachment committee of the National Assembly. Those questions which came before the Constitutional Court resulted in 3 separate judgments. The first, penned by Chief Justice Meyer and supported by 3 other justices. The second, authored by Justice Kalapan and also supported by 3 other justices. And the third, written by Justice Majid and supported by 2 others. The effect of those 3 separate judgments is that the Constitutional Court, by a majority, concluded that Rule 129L is inconsistent with the Constitution and invalid. That is the rule setting out the impeachment proceedings. It also found that the National Assembly vote taken in accordance with that rule was inconsistent with the Constitution and invalid. And it found that the report which had been issued by the expert panel must be referred to the impeachment committee. It ordered a limited severance in respect of the rule it found unconstitutional, and a reading in, which, as I said, led to the report being referred to the impeachment committee, pending any amendments which the National Assembly would itself author and make. The reading in allows the National Assembly essentially to get on now with this process of impeachment by referring the report to the impeachment committee. And it will deliberate upon the report and the issues which had been set out by the panel led by Justice Sandile Ngobo. The case, as we will know it in future, will be referred to in shorthand as EFF 3, after the Constitutional Court judgment known as EFF 1, which finalized the dispute over the non-security enhancements to former President Jacob Zuma's Nkandla dwelling, and EFF 2, which settled the need for rules for impeachment proceedings. So it's EFF 2 which ordered the National Assembly to devise the rules, which now came before the Constitutional Court, and the Constitutional Court, in effect, found to be unconstitutional and invalid. I'm now going to hand over to Kyle and ask him to give us greater insight into the court judgment. Kyle, the judgment has been heralded by several commentators as a triumph for accountability, for transparency, for the rule of law. But of course, in the second judgment, written by Justice Kalapan, we have this very interesting consideration of the tensions in our constitutional framework between majoritarianism and counter-majoritarianism, and a system or scheme, which he says, which carefully balances those two forces. And he doesn't say this quite as crassly, but essentially what Justice Kalapan is accusing his colleagues of the Constitution and the court as a whole, is of having created another constitutional disfigurement, essentially taking from the National Assembly a rule, a power that is specifically reserved to them in terms of our constitutional scheme. And I wonder how you reflect on that, and ask you to give us a little bit more insight into your thinking on the judgment.
Thanks, Nicole. Yes, there were indeed interesting developments in the judgment itself. And as you point out, the second judgment of Colopin J is indeed quite critical of the majority, or of the two other judgments that together then formed the majority on the ruling. I do, however, think that the judgment of Justice Majid then comes back and says, well, hang on, I hear you on the criticism, but let me just explain our position a bit further, and I think he does so well. So just to go back briefly, I think the background is rather clear by now. The ATM had submitted a motion to the Speaker of the National Assembly in terms of Section 89 of the Constitution, and the rules 129A to Q of the National Assembly rules, requesting the Assembly to initiate an inquiry into the removal of the President for his conduct in the Phala controversy. The Speaker appointed an independent panel, which then produced their report at the end of that year, finding that the information before it established prima facie that the President may have committed, among other things, a serious violation of the Constitution or the law, and serious misconduct, which is obviously a reference to those grounds that you pointed out in Section 89 of the Constitution, which need to be established before the Assembly would be able to vote on the removal of the President. On 13 December of that year, the report, I think, was on the 30th of November. On 13 December, the Assembly considered and debated the report before voting on whether the report was going to be referred to the impeachment committee. And the Assembly voted against that referral. And that is then what sparked the present litigation, where the EFF and the ATM approached the Constitutional Court seeking to declare that vote unconstitutional, as well as a declaratory order that the rules, which were ordered in EFF 2 to be devised, were inconsistent with the Constitution and invalid. So there are three judgments, as you point out. The first judgment is penned by Chief Justice Meyer, and it is concurred in by Madlanga, the acting Deputy Chief Justice, Justice Rogers, and Justice Turan. The second judgment is written by Judge Colopin, and with him is Justice Matopo, Justice Segobin, and Justice Cheeky. And then the third judgment by Justice Majid, with Mklantla and Justice Mklantla and Acting Justice Tolme concurring. And the court was unanimous, as you say, on it having exclusive jurisdiction to decide the challenge to Rule 129I of the Assembly rules, but they split on the validity of the rule and on how to characterize the challenge to the Assembly vote. By majority then, if we look at the overlap between Justice Meyer's judgment and Justice Majid, Rule 129I was unconstitutional because it allowed the Assembly to terminate the Section 89 process after a positive recommendation from a panel report before the factual and evaluative work necessary for a proper Section 89 determination had been done, that the Assembly vote on 13 December was invalid, and that the panel report must be referred to an impeachment committee. So that majority outcome is produced by the overlap between the first and the third judgment, who agree that Rule 129I is unconstitutional, but they get there by different routes, and that will become a little more important later on. The first judgment focuses more on premature gatekeeping by the National Assembly and suppression of a process that should be ventilated further. Whereas the third judgment is focused more sharply on the fact that Rule 129I asks the Assembly the wrong question at the wrong stage. So on the design of the Section 89 mechanism, the judgment is not about whether President Ramaphosa committed serious misconduct or whether he should be removed as president. The judgment is about whether the National Assembly rules created an effective constitutional mechanism for Section 89 accountability. That point comes from EFF 2, which you referred to in your introduction, where the Concord held that the Assembly must create rules for the removal of a president under Section 89. And those rules must do more than provide a bare political opportunity to vote. They must allow the Assembly to determine whether one of the constitutional grounds for removal in Section 89 exists. Section 89 contains 3 removal grounds: A, a serious violation of the Constitution or the law; B, serious misconduct; or C, the inability to perform the functions of office. And I think importantly, these are not free-floating political labels. There are constitutional thresholds. Before the Assembly may remove a president, it must first determine whether one of those thresholds is met. And that requires some factual and evaluative process. The Constitutional Court was therefore concerned with institutional design. The question was whether Rule 129I enables the Assembly to make the determination that Section 89 requires, or whether it permits the Assembly to avoid that determination. And the majority then found that it was the latter. The impeachment process has several stages under the Assembly rules. The motion is firstly submitted, and then the Speaker screens it for formal compliance. The independent panel then assesses whether there is sufficient evidence. The Assembly considers the panel report under Rule 129I. If the Assembly resolves to proceed, the matter would go to an impeachment committee. The impeachment committee would then investigate, test the evidence, and report back. And then finally, the Assembly votes on removal. And the issue here concerned the 4th stage on the list that I've just given. So Rule 129I allowed the Assembly, after receiving a panel recommendation, to vote, after receiving a positive panel recommendation, to vote on whether the Section 89 inquiry should proceed. If the Assembly voted no, the process ended before the impeachment committee ever investigated the matter. In this case, the panel concluded that the information before it disclosed prima facie that the president may have committed serious violations or serious misconduct, and that he had a case to answer. The legal question was whether, after such a positive panel recommendation under Rule 129G, the National Assembly could use 129I to vote against referring the matter to an impeachment committee. So basically, where the panel says we do have evidence here that the president has a case to answer, can the Assembly, after that process, nevertheless decide not to go ahead and not to send the matter to an impeachment committee, as was the case here? So that's basically the framework and the background facts. And then the first judgment is, as I say, by Chief Justice Meyer, and there are 3 justices who concur. And that judgment treats Rule 129I as a gatekeeping mechanism that allows the Assembly to block further inquiry after a sufficiently substantiated impeachment motion has already survived the independent panel stage. The key idea is that the independent panel performs only a limited preliminary function. It doesn't hold a full inquiry, it doesn't test evidence in the way an impeachment committee can, and it asks whether there is enough to justify moving to the next stage. Once the independent panel finds that sufficient evidence exists, the first judgment reasons that the Assembly cannot, at that stage, simply table, debate, and vote the matter away. Something more is required constitutionally. There must be an inquiry of some kind into impeachment motions that are not plainly unmeritorious, and there must ultimately be a determination on whether a Section 89 ground exists. This is why the first judgment describes Rule 129I as making the Assembly a gatekeeper at the wrong point. The Assembly's majority could prevent the process from ever reaching the stage where allegations are properly investigated, where evidence is tested, and the public can see the basis for the decision. Hence, the first judgment concluding that the positive panel recommendation must be implemented through referral to the impeachment committee, unless and until the report is set aside on review. And that will also be a little important later, because the independent panel report is not treated as immune from review. The report remains operative, but it can still be challenged. The first judgment recognizes that the evidentiary basis may collapse once the impeachment committee starts its work. And this is what I was referring to earlier when I said that this judgment is not about whether the president has committed a serious violation of the Constitution or serious misconduct. It's about the process in terms of the rules. And here the first judgment says that it's not to say if the Assembly proceeds to the next stage, which would be the impeachment committee, that they are certainly going to go ahead and find that the person is guilty. What they're saying is that it needs to get to that stage before that decision can be made. So the independent panel, if they find sufficient evidence, the matter must go to the impeachment committee. The impeachment committee then performs a distinct investigative function. And if it becomes clear that the case cannot be sustained, the independent committee may, if the rules permit, recommend early termination. This is an important distinction because the Concord is not forcing Parliament to pursue impeachment mechanically. It's insisting that the decision to stop must be taken within a process capable of testing the allegations, not by a politically conclusive vote before the process begins. So that's the first judgment. Then I'll jump to the third judgment and return lastly to the second judgment. The third judgment is written by Justice Majid, and there are two other justices who support that. And the third judgment agrees that Rule 129I is unconstitutional. The reasoning is sharper and I think a little more useful for today. The central point is that Section 89 requires the Assembly to determine whether a listed ground exists. Rule 129I didn't require the Assembly to answer that question. It required the Assembly to decide only whether the inquiry should proceed, which is a different question. The Section 89 question is whether the president committed a serious violation, serious misconduct, or is unable to perform the functions of office. The Rule 129 question was whether the matter should proceed to an impeachment committee. And the third judgment says that a constitutionally required decision cannot be replaced by a discretionary procedural decision on whether to make that decision. Rule 129I allowed the Assembly to avoid deciding whether a Section 89 ground existed by creating this kind of procedural off-ramp. And the Assembly could stop the process without ever reaching the constitutional question. The rule thus left the Assembly voting in the air, in the words of Justice Majid, as the vote was not tethered to the existence or non-existence of a Section 89 ground, nor to the veracity or seriousness of the allegations. Secondly, the third judgment distinguishes between political discretion and factual foundation. So impeachment is ultimately decided by elected representatives. Section 89 contains a political dimension. The Assembly retains discretion even where a ground is established, but it is not the same as a motion of no confidence. Section 89 removal depends on the existence of specified constitutional grounds. If those grounds aren't considered and established through a rational process, impeachment is reduced to an ordinary majoritarian politics with a higher voting threshold. So the third judgment treats the Assembly's Section 89 function as having both a factual component and then a normative component. What happened, and does the conduct meet the constitutional standard of seriousness? Rule 129I allowed the Assembly to terminate the process before the factual record was developed and before the normative evaluation could properly be made. And this is why the impeachment committee matters. It is the mechanism through which allegations are tested, the factual record is developed, and the Assembly is placed in a position to decide the Section 89 question. Thirdly, Justice Majid says that the rule is defective because of its structure and not just because it was abused. This is where the second and the third judgments diverge. So Justice Colopin, who wrote the second judgment, says that even if the Assembly acted unlawfully in this particular case, that does not mean the rule itself is unconstitutional. A lawful power can be abused, and if it is abused, the remedy is to review the exercise of power, not to invalidate the empowering rule. In other words, to challenge here the vote and not to challenge the rule. Justice Majid rejects that analysis, though, and his answer is that this is not merely a case of a good rule that's being abused. The defect is built into the rule, as Rule 129I itself permits the process to be terminated after a positive panel finding, before the Assembly has performed the constitutional task that Section 89 assigns to it. And that distinction is crucial because if the problem were merely abuse, the remedy would be to review the National Assembly's vote of 13 December. But if the problem is structural, the rule itself must be invalidated. And the majority's ultimate order reflects that structural view. Both the rule as well as the vote that was taken under it are unconstitutional and invalid. Then I just wanted to say something briefly about transparency. The first and the third judgments both rely on transparency, but in slightly different ways. The first judgment treats transparency as part of democratic accountability. If the process is stopped too early, the public cannot see the allegations tested, they cannot assess the relative merits, and they cannot hold representatives properly accountable. The third judgment of Justice Majid goes further. Transparency in the third judgment is not only about the public's right to know, it is also a condition for the Assembly itself to exercise its Section 89 power properly. The National Assembly must decide on a properly developed factual basis, and the public must be able to understand how that decision was reached. I think that is the correct, or that must be correct, because transparency is not merely a value on this argument, it is part of what makes the Assembly Section 89 decision constitutionally legitimate. And then I'll move to the second judgment, which was written by Justice Colopin, and it is the dissent. And it presents a strong institutional argument. Justice Colopin starts by saying that Section 89 vests the removal power in the National Assembly. The panel is a creature of the National Assembly's own rules. So it advises, it doesn't decide. And on that view, it would be constitutionally problematic to make the panel's recommendation binding on the Assembly. The second judgment's concern is that the majority risks transferring, the majority of the Constitutional Court risks transferring power from the Assembly to the panel. If a positive panel recommendation automatically triggers referral, then the Assembly loses the ability to scrutinize the report and reject it where there are proper grounds to do so. So, for example, if the panel misunderstood its mandate, relied on unreliable material, or made unsustainable findings. The second judgment argues that majoritarian decision-making is not inherently suspect. The Assembly is a political body. Its constitutional role should not be weakened merely because the majority may vote in a partisan way. There are lawful ways to challenge unlawful exercises of power, but that does not mean the rule conferring the power is invalid. So the second judgment's position is that the rule is constitutionally valid. The panel is advisory. The Assembly must be able to consider the panel report. A majority vote at that stage is not automatically unconstitutional. And if the Assembly abuses that power, the vote should be challenged rather than the rule invalidated. I think this is a strong separation of powers argument. However, the first and third judgments do not say the panel decides whether the president is guilty, that the panel decides whether the president should be removed, or that the Assembly is bound by the panel on the merits, because that's essentially what the second judgment is saying. It says that the first and third judgments are allowing this panel to do the work of the Assembly, that whatever they find or whatever the panel finds in its report, that must be adopted. And that's not really what's being said. The point made is a narrow one. So a negative panel recommendation may allow the Assembly to conclude that no sufficient basis exists. A positive panel recommendation does not establish guilt. It means the constitutional question in Section 89 remains unresolved. And because that question remains unresolved, further inquiry is needed. That further inquiry is conducted by the impeachment committee, and only after that can the Assembly make an informed Section 89 determination. Justice Majid expressly addresses this double standard criticism when he says a negative panel recommendation and a positive panel recommendation are not constitutionally equivalent. If the panel says there is not sufficient evidence, there may be no factual basis on which to continue. But if the panel says sufficient evidence exists, it means the ground may exist and thus requires further investigation. In other words, the panel is not made supreme. It remains a sifting body, but once it finds that the threshold has been met, the Assembly cannot use an unguided political vote to prevent the very process needed to decide whether the allegations are true. And then I just wanted to speak briefly about that kind of partial discretion that is left with the Assembly. In the case of a positive panel recommendation, in other words, where they say there is a case to answer, the court says the matter must go to the impeachment committee. In the case of a negative panel recommendation, the Assembly may accept that the matter goes no further, but they may nevertheless resolve to proceed to the impeachment committee. That is built into the final order. The read-in version of Rule 129I says that where the panel concludes that sufficient evidence exists under Rule 129G, the matter must be referred to the impeachment committee. But where the panel concludes that sufficient evidence does not exist, the Speaker must schedule the report for consideration by the Assembly. And if the Assembly nonetheless resolves that a Section 89 inquiry should proceed, the matter must also be referred to the impeachment committee. So the majority position can be summarized as the panel's positive finding prevents the Assembly from terminating the process before the allegations have been properly tested. But the panel's negative finding does not prevent the Assembly as the ultimate constitutional decision maker from requiring further inquiry. And that is the partial discretion. The Assembly retains discretion to proceed despite a negative report, but loses the discretion to terminate despite a positive report. And Justice Colopin criticizes precisely this asymmetry. He says the first and the third judgments appear to require the Assembly to accept a positive panel recommendation, in other words, to proceed to the impeachment committee, while allowing it to override a negative one. So even if the panel report says there isn't any evidence that there's a case to answer, the Assembly could nevertheless proceed to the impeachment committee. And according to Justice Colopin, there's no conceivable reason for treating positive and negative recommendations differently. Justice Majid answers that criticism, and he says it assumes a false equivalence between the two very different situations, a case where the panel finds no sufficient evidence and a case where the panel finds sufficient evidence. Those are not constitutionally interchangeable positions. They call for different responses. So in conclusion, the judgment does not make the independent panel the final decision maker. The National Assembly remains the ultimate constitutional actor. The Concord's remedy creates an asymmetrical process. If the panel finds that sufficient evidence exists to disclose a prima facie case, the matter must proceed to the impeachment committee because the constitutional question in Section 89 remains unresolved and thus requires further inquiry. If the panel finds that sufficient evidence does not exist, the Assembly may bring the process to an end, but it is not bound to do so. It may still require further investigation. So I think this preserves the Assembly's ultimate authority while preventing it from using a political vote to terminate the process where the panel has found that there is a case requiring investigation. And that is my analysis, Nicole. So I will leave the rest for the questions. Especially about what the possible consequences are if this report is taken on review, whether that suspends the process or otherwise. Thanks.
Great. Thank you so much, Kyle. Thanks very much for very comprehensive analysis. It's no secret, I think, which of the judgments you find most compelling, but that was enormously interesting and I think very persuasive. Thank you for that. Lukhona, I'm going to turn over to you at this point. I'm wondering if, in the midst of all of this, if as sort of administrative layer gets heaped upon administrative layer, in respect of this debacle, the president is smiling in a way because it takes him further and further from the underlying facts, which are so incredibly bewildering, right? That millions of US dollars are taken from a couch, stolen from a couch in his game farm, which ostensibly come from some Sudanese businessmen who decided to go cattle shopping on Christmas Day, found the farm available, ostensibly paid millions of dollars for these cattle, has never taken them with him. And those millions of dollars are then stolen and not reported. And the president's official powers, nonetheless, are sort of used to keep that investigation to the extent that there is secret. And so I suppose to the extent that we're talking about sort of judgments of this type, we are further and further from what must be one of the, I think the South African public has had to, accept and swallow a large number of fairly unbelievable stories, but this must be one of the greatest of them. But how does the Constitutional Court case now figure in a bigger political context and matrix, and what are the implications going forward? And just before I hand over to you, can I just ask everyone who is with us, there will be an opportunity for questions going forward. But if you have questions now, please just pop them in the chat and we will refer to them once Lukhona has made his presentation. But over to you, Lukhona, and thanks very much.
Thank you, Nicole. And I think, thank you, Kyle. I'm indebted to you for the comprehensive layout of what transpired on the 8th of May at the Constitutional Court. So I will probably keep my comments brief so that we can have a conversation among ourselves. I mean, I see some the participants are equally people who sometimes hold very strong views about the developments in our country. I think the first is that the Constitutional Court judgment affirms the foundation of our constitutional democracy, and that we still have institutions that do not necessarily make political considerations only, but they keep to the spirit of the Constitution, particularly where holding those who are vested with executing executive power accountable. Because, I mean, really matters find themselves before the courts because somebody's aggrieved with an exercise of one power or the other. I do think, though, it also highlights a continuous attitude from Parliament to really not robustly sense check the manner in which they formulate our laws, or in the way in which they formulate the rules that govern how Parliament ought to behave. Because it was quite clear to me when the rules were published that Rule 129I is defective at foundation. It was very clear. There isn't even a debate about that because you cannot start a process that is founded in the Constitution, not in the rules themselves. The rules are simply to execute a constitutional provision. So if something is wrong or if there's prima facie evidence that something is wrong in the conduct of the president, insofar as the panel, the independent panel is concerned, it's quite it's just a logical issue for me, at least. I mean, of course, Kyle has now spoken quite clearly about how the two judgments, particularly Judgment 1 and Judgment 3, eventually converge at 129I being unlawful and unconstitutional. But I must say, I am much more happier and persuaded by the reasoning of Justice Majid and Chikri, if I'm not mistaken. But that judgment penned by Majid really persuades me properly as to the real problems, how you cannot circumvent accountability, transparency in that accountability process. Because effectively what 129I did politically is to say, if you can secure a majority, even if there's prima facie evidence that something is wrong in the conduct of the president, but if you have enough majority in Parliament to protect you, that 129I kicks in and it foils any possibility of ventilating properly through a proper impeachment committee that has investigative powers and has resources that are not at the disposal of the independent panel, because the independent panel can only assess information that comes before it through submissions that are made by members of Parliament. They can't subpoena, they can't do this and call witnesses in front of them and so on. So I think politically, first of all, it's to say Parliament really needs to conduct itself in a proper manner. It needs to take enough counsel. It needs to ensure that it robustly champions the Constitution, because effectively what ends up happening is if the Parliament weakens on its role on holding the executive accountable or designing laws and rules, then these matters find themselves to the courts, and eventually the issues that should have been sorted out in the political arena are resolved in the judiciary, and it taints the judiciary to a large degree in the sense that if it is seen to be confrontational, and I mean, if you then get a judgment like Judgment 2 by Call Upon, where it debates this issue of, majoritarianism. Yes, majoritarianism is there, but it cannot be abused either. And so that power has to be checked. And that's why judicial reviews are important in the work of Parliament. But I think when you get too many issues appearing before our courts, which should have been resolved by sensible politicians who champion their oath of office and who champion the spirit of the Constitution, then actually you insulate the courts from, becoming highly politicized. And I think that's something that going forward, our lawmakers really need to take seriously, because as you saw that, I mean, in the build up to that Constitutional Court judgment, the Court's own credibility was now becoming, to be placed in doubt. As if they are playing a political game. They've taken too long to deliver the judgment. Of course, the issues are quite heated and so on. And the more heated, the more heated. Sorry, if we could please. The more heated the matters before the courts, the more at risk the perceived credibility of the courts. And it may not be that the courts will stop conducting themselves impartially, applying the law, developing our jurisprudence and all of that, but the perception in the broader public may build that the courts are brought into the political arena. The second part, Nicole, that you raise in your question to me is the more important part. Whatever legal mechanisms are available to the president, and he can exercise them as he so wishes, just as former President Jacob Zuma has been exercising legal mechanisms available to him for 21 years to evade trial in the arms deal issue. So the president himself could do that. In the one sense, he may be seen as somebody who does not want to be held to account. So he doesn't eventually want to be held accountable over this Phala matter. On the other hand, for the citizens, though, because the set of circumstances in this whole Phala matter are just so bizarre, it is only fair and just that a process that has, public buy-in, public legitimacy, is undertaken to try and put the matters around Phala to rest, and for citizens to say, but a bizarre incident once occurred in our lifetime, but there were enough safeguards to ensure that there's accountability, whether the president is eventually found to have committed any wrongdoing or not. But there was a mechanism that was developed, because what has been happening, the kind of reports that have been published around Phala, whether it's the Public Protector Report, whether it's the Reserve Bank report, the South African Revenue Services report, and so on. And of course, now the declassified IPID report. These reports have all been undertaken, behind closed doors by nature of the institutions and their mandates and what they were asked to do and to eventually determine. So it's important that some public process, and I think, I mean, if there wasn't much to hide about Phala and that the facts were the way that, they were exposited. And I think there's always a tension between the initial response by the president in Parliament and then his submission to Justice Sandile Ngcobo in terms of giving record of the sequence of events in terms of what transpired in Phala. And when then you prolong the process towards accountability, it begins to open up room for conspiracy theories to take center stage. And in a political environment, that becomes significantly dangerous when you open up that room, because you always want to shut the door to the point of, you always want to shut the door to the points of conspiracies. But also when you prolong, it also gives a perception that there's something wrong here, something amiss, and potentially there are issues of guilt that are at hand that, are being covered up. And of course, yes, if you look at the processes undertaken, particularly by Wally Rode and Bejani Chauke, there seems to have been an attempt to cover up the issues and what transpired between this side of the border and the other side of the border in Namibia. And, state resources were used and abused, and there's still no sense of urgency to hold Rude accountable, and he remains the head of the president's unit, and the president is not about to throw him under the bus, which then ferments the idea that Rude was not acting at his own accord. He was acting at the behest of the president. So these issues then become important to say there are layers, and what you may call administrative layers, we may call it layers and layers of lack of accountability in terms of how this entire issue is handled and the processes that have unfolded since the issues have come to bear. Of course, then recently you also get indications that there are investigators who are now looking at the fact as to whether the amount that is now publicly disclosed in terms of how much the dollars were is actually the right amount, or there must have been more money that was stuffed in the couch and in the mattresses of the Phala game lodge. And I mean, Arthur Fraser has to a degree indicated that he believes that there was much more money, which then means the entire narrative around a Sudanese businessman who is probably one of the most romantic men in the world, buying, buffaloes on Christmas Day, is actually a false narrative, and that it is a cover-up of really what that money was for, where it came from. And we must not forget that at some point, we've had instances where foreign currency was stolen from the state security agency offices in this country, and we still don't know where that money ended up. We have instances where there are allegations of people who are laundering foreign currency into the country for purposes of financing political activities. And whether that money really even belonged to Ramaphosa himself, we also have to just try and look at things in sequence and logically. I mean, he does say he arrived at Phala after Christmas, so he was aware that the foreign currency was there. But I mean, it was never his business to determine what is done with the money, when and how, because the businesses people that run it. But I mean, if you are a real person like Ramaphosa, who has serious interests, has a lot of money, has wealth, if that money really truly was his, I'm sure he would have had some desire to keep following up exactly, was the money declared properly, was it banked? Because I don't think that it's every day where you sell buffaloes using cash transaction. And therefore the underlying facts on this issue really need a thorough and piercing investigation that can give everybody some assurance of exactly what happened, how it happened, and why are we here. And lastly then, Nicole, I think that of course the questions that would confront the president now politically are, how he handles his relationship with his GNU partners. Even though the case was taken to court by the EFF and African Transformation Movement, ATM, the DA, by virtue of being an anchor partner in the government of national unity, has a lot of has a lot that comes to bear when it comes to the outcome of this, because they stand for constitutionalism, they champion accountability, and therefore they cannot dilly-dally where the president is concerned. What will be of interest is whether or not the DA politically will choose to confine its political tension with the president on the issue of Section 89, and not extend it if, for example, as a result of the president being seen, to be trying to counter Parliament, particularly if he does bring an interdictory order to stop the impeachment committee whilst he pursues the review of the independent panel led by former Chief Justice Sandile Ngcobo. If then Parliament says, okay, we accept that you have the legal instruments to avoid accountability, but we are unhappy that you are frustrating the business of Parliament, and therefore Parliament has lost confidence in you as the president, and then a Section 102 motion of no confidence is brought against the president. Politically, what does the DA do in that instance? Does it say, we are not going to vote with MK party because they are trying to destabilize government? I mean, we've seen the Minister of Police coming out to say impeaching President Ramaphosa would destabilize the country. So it's quite clear that there's a narrative that is being built up in some quarters to say that in actual fact, let's probably try as much as possible to avoid this process, even the impeachment committee process itself. So it's beginning to gain certain legitimacy in some ANC circles, which is problematic for the DA, because then when a motion of no confidence is brought before Parliament, they then have to make a decision whether to vote to protect President Ramaphosa, as will other GNU partners. But I single out the DA because they hold the keys. I mean, if the DA votes with the ANC, that's a good over 60%. There's no questions that the motion of no confidence does not pass. But I think perceptively, it's going to get to a point where this issue of Phala, given the occurrences in different, fora, in the Matlanga Commission, in the Edo Committee, and so on, to say South Africans perhaps are losing patience with people who are seen to be defending and trying to avoid, trying to ensure that some people avoid being held accountable, and therefore the DA may well lose, some support amongst its voters or supporters if it votes with the ANC to protect the president and keep him there. So I think it's going to be interesting what happens between now and probably the next 3 weeks, insofar as the president's own legal strategy, if it includes interdicting Parliament from proceeding, and whether the courts will grant that interdict, given that it's actually in the order, I think Order 7, that the Sunday Ngcobo report must be sent to an impeachment committee. It doesn't even say Parliament must make a consideration and so on. It really just opens wide the gates for an impeachment committee. Of course, people then rely on a paragraph in the judgment, I think paragraph 135, where Maya is discussing, what happens with the report of Section 89 unless there has been some review of that, successful review of that. And it will be interesting to see the interpretation of all of those things. So both legally and politically, I think we are in interesting uncharted waters, but this is probably good for jurisprudence in terms of developing the law around Section 89, what is expected of Parliament as an institution and how it ought to conduct itself, and then, therefore, what parliamentarians ought to do in future, and so on. So I think that lastly, for the president, unlike the first time in December 2022, when there's enough record, even though the spokesperson of the president might want to deny this, there's enough record, even from his own ANC colleagues, even from other people, that the president did want to resign after the Sunday Ngcobo report was published. Now he seems to have some renewed confidence and some level of protection from the ANC, and that maybe he could have a prolonged legal strategy, because I have no doubt that the Phala issue potentially implicates the ANC as well, and that is why they are so invested in ensuring that they protect the president and he doesn't go through with accountability anytime soon. And particularly given that it's local government elections coming up, I have no doubt that there might be an attempt to try and ensure that the impeachment committee is stopped in its tracks, because I think the ANC can't afford any more embarrassment than it has taken in some of the other committees and the things that have been put to the fore for the public. So I'll leave it at that for now, and perhaps we can have a conversation. Thank you, Nicole.
Thanks so much, Lekona. That was very well done in and of itself, but it was especially admirable and endearing in that you were giving your analysis and obviously being a attentive father. So well done to you. There are a number of questions that have been put in the chat, and I am going to ask those who want to ask questions and haven't done so, to put your questions in the chat. I am going to, at this point, direct some of those questions to our speakers. So the first one, I think, is best answered potentially by Kyle. And the question to Kyle: is it premature to seek a review of the report of the impeachment panel? Why not look to defend in the impeachment process itself? So that's the first question. The second question is, and I think, Lukhona, this one is potentially best answered by you, is if the impeachment process continues, if it continues apace in Parliament, are there going to be a lot of political trade-offs? Can we envisage that there will be? The third question, again, I think probably for Kyle, is if the review of the report of the impeachment panel succeeds, does the whole process then cease? A fourth question, and this goes to a vote of no confidence, a motion of no confidence rather than impeachment proceedings. But the question is, if the National Assembly is allowed to vote for a motion of no confidence, and that motion of no confidence passes, what is the president's position thereafter? And then the last question for this round is, should the president choose to resign from Parliament, is he still required to appear before the impeachment committee? And so I will give Kyle an opportunity now to answer some of those questions, and thereafter Lukhona. Thanks very much.
Thanks, Nicole. Interesting questions indeed. Yeah, I wanted to just start first with the strengths of the second judgment. I understand that you said after I had done my initial analysis that it wasn't a secret which judgment I had agreed with. I did, however, want to point out some strengths in the second judgment. And I think that is that it takes seriously the fact that Section 89 vests the impeachment power in the National Assembly and not in an independent panel or court or expert body or technocratic screening institution. And that is not a minor point. Impeachment is a constitutional process, but it is also an intensely political one. It concerns the removal of a sitting president by elected representatives. Justice Colopin's judgment is powerful because it resists converting a preliminary expert recommendation into a legally binding trigger that compels the Assembly to move to the next stage. The judgment is also strong on institutional competence. The independent panel exists because Parliament created it through its rules. It is advisory, it has limited powers, it doesn't conduct a full inquiry, and it cannot finally determine whether a president has committed serious misconduct or a serious constitutional violation. Justice Colopin's concern is that if a positive panel report automatically requires referral to an impeachment committee, the panel begins to exercise a kind of controlling power over the Assembly's agenda. That may be attractive where one distrusts the parliamentary majority, but it is constitutionally uncomfortable, I think. An unelected preliminary body would, in practical terms, be forcing an elected representative into a major accountability process, even where the majority believes the panel's reasoning is weak or speculative or flawed. A further strength is the judgment's distinction between the validity of a rule and the abuse of a power under that rule. So Justice Colopin's point is not that the National Assembly can act irrationally or dishonestly. It is that if the Assembly misuses a valid rule, for example, by voting down a report for improper partisan reasons or without rational engagement with the evidence, the remedy should be to challenge the decision. It doesn't follow that the rule itself is unconstitutional. And then, yeah, politically, I think the second judgment has intuitive democratic appeal. Parliamentary majorities are often partisan, but that is how representative politics works. The Constitution gives the Assembly, not courts or panels, the final responsibility to decide whether a president should face removal. Voters can punish the majority that shield the president, and opposition parties can campaign based on that failure. Civil society can expose it, the media can interrogate it, And although that may feel unsatisfactory in a dominant party system, it preserves the basic political character of impeachment. Yeah, so that's all I wanted to say. The second judgment's strongest point is this: accountability must be effective, but it must remain parliamentary accountability. The cure for partisan majoritarianism should not be too readily to bind Parliament to the recommendation of a body that Parliament itself created only as a preliminary advisor. Whether President Ramaphosa resigns, and if so, if he would still have to face the impeachment committee, I think that's an interesting question. The ordinary Section 89 impeachment process would most likely fall away. And I say that because Section 89 is a mechanism for the removal of a sitting president from office. Once he is no longer the president, I don't think there's no longer an office from which the National Assembly can remove him. So in that sense, the legal basis for continuing a Section 89 removal process becomes doubtful. But Parliament would still have an accountability interest in investigating the underlying facts, especially if those facts concern the abuse of office or the misuse of state resources or breach of constitutional duties. And the question is whether that investigation can still proceed as a Section 89 impeachment inquiry, or whether Parliament would need to reframe that as an ordinary parliamentary oversight inquiry. I think it would be the latter. And then the question about whether the panel report would be premature in a review application. I think there's considerable force in the view that the panel report is preliminary, it's not final, and that a court should be slow to review it before the impeachment committee has done its work. And that the point that I made earlier about this two-stage process, the first one being factual, where what happened here, and the second one being normative, which would be done by the impeachment committee. Does the conduct complained of meet the standard put down in the Constitution? That would be the normative part. So the panel doesn't determine guilt. It does not remove the president. It doesn't finally determine that a Section 89 ground exists. It only expresses a prima facie view that there may be a case to answer. On that basis, one could argue that a review is premature because any factual or legal misdirections in the panel report, the factual stage, could be corrected in the substantive committee stage, where the president can respond more fully and the evidence can be properly tested. So that argument would rest on ripeness and final effect. But the counter argument is also a serious one. And the Constitutional Court treated the report as having enough legal consequence to trigger the next stage. Justice Meyer's judgment says the matter must go to the impeachment committee unless and until the report is set aside on review. That phrase strongly suggests that the court contemplated review of the panel report before the committee process is completed. So it doesn't decide the ripeness point, but it makes it difficult to say that such a review is categorically unavailable. The president could argue that the report has immediate legal effect because it compels him into a serious public impeachment process. It exposes him to reputational harm. It triggers an institutional process that would not otherwise occur. And on that view, the prejudice is not only final removal, but being subjected to an impeachment inquiry on the basis of a report said to be irrational, procedurally fair, or legally misconceived. So yeah, my view is that the ripeness argument is powerful, but the Concord's wording makes it likely that a court would at least entertain the review.
Thanks very much, Kyle. Lukhona, can I ask you to respond to those questions that were directed to you or that you would like to respond to?
No, thanks, Nicole. I think, well, look, there's no doubt that the ground has shifted in Parliament by virtue of having a hung National Assembly in this administration. And I see now news is that the Speaker has actually turned down the Section 102, subsection 2 motion of no confidence application by the ATM. So that scenario now falls off, at least for now, unless something else transpires. The posture of the Speaker will be very interesting insofar as an interdict application, whether she will seek to abide by the court's outcome or significantly defend the role of Parliament to continue with its work in terms of the impeachment committee. And so, yes, that will be, of course, there will be trade-offs, but I mean, I don't think the kind of trade-offs we would have thought about under ordinary circumstances. So there's no doubt that the EFF is not going to abandon its own legal victory. Therefore, it will probably want to proceed as much as possible rather than saying, oh, well, let's then trade off, abandon the impeachment committee process if we are taken into government and so on. I think the credibility crisis would be far too large for them if they traded off that way. And I think the EFF, MK, ATM universe is once more united around a particular campaign in Parliament insofar as this is concerned. Remember that all of these parties have a material interest to see Ramaphosa go, whether it's political opportunity or not. That's a different question. They are political parties. I don't understand if people say they're being opportunistic. How else do political parties do politics sometimes? They use opportunistic moments. It's quite clear. They didn't invent what happened in Phala. It's a clumsy thing that happened and that the president dragged himself to be involved with. And it's coming back to bite him. So, I mean, I think both sides can be weighed up in interesting ways. And I know that we sometimes look at questions around timing. I saw a question around timing, what was the timing of Arthur Fraser and so on. Of course, there is a broader political game happening behind the scenes. And remember, this whistle on Phala was blown towards an ANC conference at a time, where things were quite heated up and President Ramaphosa was due for a second term re-election. Of course, those kind of things do matter. And it's quite clear that people like Arthur Fraser, though they've been entrusted with bureaucratic roles, if you listen to his recent interview with Mzilikazi wa Africa, is that he's got a very serious political posture in terms of how he behaves and how he maneuvers around the South Africa's political terrain. And I think therein lies the difficulty just in our politics, is that as Batabile Dlamini once said, everybody has their own skeletons, and there is the material risk of being held up by continuous revelations of skeletons and so on. I mean, even with the stuff happening with the police, I don't think we've got the full vista of what is going on, and Mazlanga is not going to be able to unearth all of it, but we definitely have some rearrangement of power and factions within the police service, within the political and administrative interface, insofar as the security cluster is concerned. So I think the function is that I don't see. Let me just answer one last question, and then maybe Nicole, you can put others further. I don't see the DA, if the impeachment committee comes to an outcome that says, this report, we are tabling it to the National Assembly for a vote. There's material. There's enough material for us to believe that the president, acted in a way that violated the Constitution, and they can go to questions around, issues of conflict of interest and all of these things, the questions around declarations, not exposing yourself to any potential, because the Constitution is very clear on the executive. You can't even expose yourself to the potential for a conflict of interest. It's a constitutional provision. And of course, whether you are doing remunerated work and so on, when the president stands up before an ANC meeting and says, everybody knows I'm a farmer, I sell cattle and buffaloes and so on, is he in a basic, average man on the street reading, admitting that besides, being a president, he's got additional income and he's effectively doing that work. And of course, those people who have seen him at auctions and so on, he's quite materially involved in that business. Is it a hobby? Is it a business? And I think those things really do need a bit of testing, and putting him on the hot seat and having, members of parliament asking the tough questions. And this is why I'm saying, for me, just on the basis of the facts of what happened at Phala, or at least the purported facts of what happened at Phala, there is enough room to say an investigation that has public confidence is warranted. You cannot have a head of state implicated in a situation where his private residence was utilized for storing foreign currencies, not even local currency, foreign currency, which then means that foreign currency has a source in terms of where it came from. And it was not inside the country. Unless it was inside the country and it was stolen from somewhere else. So I think there is enough room for pressing for that accountability. And I think for me, I mean, look, if you read the Sandile Ngcobo report lastly on these issues, it may well have been written in haste. And sometimes I think it's because of the limited window that panel is given to conduct its business and submit a report to the speaker. And therefore, I think a court may well be sympathetic about, I mean, some people talk about evidentiary basis, is there sufficient evidence? Is there prima facie evidence? What is really the standard that was used and so on? I think the court will probably be sympathetic to that report and its authors if it reads the rules that govern the Section 89 properly, and therefore would probably say, well, let a much more thorough process ensue. It is in the interest of accountability. And therefore, what everybody might be banking on is that this thing might be drawn out for a long time. But what you may end up with actually are processes wherein courts actually treat this issue urgently because there's already a court order from the Constitutional Court and they want to safeguard the centrality of the judiciary, and therefore they act expeditiously in handing down judgment, even if it goes through appeals all the way to the ConCourt. And then by December, maybe you've got a final determination on the review part of the matter, and then this issue is back. And of course, the ANC goes to a conference next year, and then it becomes also a political football within the ANC and probably continues to weaken the ANC in actual fact, as the factions may take different standpoints in terms of the proceedings in the impeachment committee. So I think it's going to be interesting whilst the ANC closes rank now, but once the leadership race, and if the impeachment committee is frustrated not to begin now, and maybe there is a successful interdict, and then, what may end up happening is that the impeachment committee comes at a time where it is ripe. And we've seen this when factions are at their zenith in the ANC, you start seeing some ANC members of parliament acting in a particular way that doesn't necessarily take marching orders from the Luthuli House. So whilst we think of political trade-offs, I think if this process gets drawn out much longer, the political trade-offs that we might even want to look at and really try and understand and analyze may well be the political trade-offs even inside the ANC and not just inter-party political trade-offs. Thanks, Nico.
Thanks very much, Lekona. Thanks, Kyle. We're sort of heading to a close now. I'm actually going to ask our two speakers just to give us 1 or 2 minutes concluding remarks. Wanted to thank them for a really insightful, valuable webinar. They have sort of made their time and their expertise so generously available, and we are very appreciative of that. I think, most of the questions in the chat have been touched on. There was one question from Coogan, which I think is to anticipate the impeachment committee. And he asks, is there an issue of conflict declaration when the president assumed office? And of course, that is one of the questions to be investigated by an impeachment committee if it moves forward. I wanted to ask, if Lekona and Kyle want to take this up in their concluding remarks, can we envisage a situation where the impeachment proceedings move forward, that an impeachment committee does make a determination that the president has committed a serious violation of the Constitution or of the law, or has committed serious misconduct? And notwithstanding such a determination, the National Assembly nonetheless votes not to impeach, and what the consequences of that might be for the health and sustainability of our democracy. But as I said, I mean, it's really over to you just to final thoughts in respect of the webinar and what we've been discussing. Let's start with you, Lukhona, first.
Thank you, Nicole. I mean, mathematically, if the impeachment committee says, yes, there's grounds for the president to be impeached, but it goes to a National Assembly vote, mathematically, the ANC has 40%. Section 89 is very clear. You need a 2/3 majority to successfully impeach the president. What I think is also interesting, and I mean, Kyle canvassed this a bit. I mean, the legal scholars seem to be in some consensus that if indeed the president resigns, then the impeachment committee falls away. What may well be an interesting question in future for parliamentarians is, given that Section 89 is not just about the removal of the president from office, the motion of no confidence also achieves that, and it does so at a far less threshold. What is important about Section 89 is that it strips the president of his or her benefits of office, post-office. And therefore, the question is, in future, may well Parliament take a posture that says it cannot be correct that a president may commit such serious, omissions of the law, of the Constitution, or violations of the Constitution, and then still be allowed to simply resign and keep their benefits. Could Parliament then go after a president who has resigned in an attempt to strip them of their benefits of office if they don't believe that they deserve them? I think that's one big question that we will have to contend with going forward into the future. And I think lastly, Coogan asked an interesting question about, in terms of conscience, what would, any ethical leader do? What would Mandela do? I think the horse has completely bolted now insofar as that is concerned. The president bides time even on acting on his own executive members who are, implicated in unethical behavior, as it were. We've seen him finally act on CCC Tolashe, but we're still waiting an action on Marubini Ramokgopa. We know that the Senzo Mchunu matter is still awaiting the Madlanga Commission. So I think we have gone beyond the realms of at least viewing or judging this president through an ethical leader type of realm, if there's anything that ethically would make him leave office and so on. Thanks, Nicole. And thank you so much for moderating us and hosting us.
No, thank you. Kyle?
Yes, Nicole, I do have a few remarks to end. The first was, I think I might have, I just wanted to touch on whether if the report is set aside in full, would that mean that the impeachment committee process falls away? If the High Court sets aside the independent panel report in full, the impeachment committee process would probably fall away because the Constitutional Court's order sends this particular report to the impeachment committee. If the report is not legally valid, that trigger for the committee process is removed. Parliament would then need to regularize the position, either by starting a fresh Section 89 process or appointing a fresh panel or reconsidering the matter under the corrected rules, or acting in terms of whatever remedy the reviewing court grants. I think a lot will depend on how that order of the review court is made. If the report is set aside in full, the committee's foundation is seriously compromised. But if only parts of the report are set aside, the answer would depend on whether enough of the report survives to support the conclusion that there is a prima facie case requiring further inquiry. But then there are also interesting possibilities if the court remits the matter and a new panel needs to be created, or if they suspend the order, there could be interesting possibilities. I think also your question is a very good one, and I don't attempt to answer it now. But I think it could perhaps also be the answer to Justice Majid's judgment, because you're saying if the impeachment committee goes ahead and they find that one of those grounds in Section 89 is established, what do we do if when the National Assembly has to vote on that, they still decide, no, we're not going to go ahead, whether that's because of the ANC's 40% or otherwise? What does that say about our democracy and whatever? And I think, excuse me, I think that then is okay to happen because of the points that I made earlier about political parties perhaps campaigning based on that vote in future. Just citizens generally seeing what has happened and still how the National Assembly, who are the elected representatives, have chosen to vote even in the face of a impeachment committee report that says there should be impeachment because one of the grounds is established. Yeah, and I thought I would leave it there. Thanks, Nicole. Thanks also for facilitating this interesting discussion. Thanks also to Lekhona for his insights.
It's been a great pleasure. It's been a great pleasure having you. Thank you again. Thank you to everyone who's joined us on the webinar and for the questions that have been asked. And we will see you again shortly. But we will leave it here and have a good afternoon, everyone. Bye-bye.
Okay, bye-bye.
Bye-bye.